Hey future advocates, welcome back to MD's iLaw channel. I'm Kritik, and today, we're wrapping up our AIBE 17 previous paper analysis series. In this final video, we'll cover arbitration agreement and how it will be terminated, other sections from Arbitration and Conciliation Act, some personal laws like Hindu law, Muslim law, and what is extrajudicial confession. Leading questions extra in this video. I'll share key insights and answer common questions to ensure you're fully prepared. If you found this series helpful, please like, share, and subscribe for more legal content. Let's dive in and finish strong. 91st question is: which of the following section deals with arbitration agreement in Arbitration and Conciliation Act, 1996? The correct option is B, Section 7. Definition: an arbitration agreement is an agreement to submit disputes to arbitration. It covers disputes that have arisen or may arise between parties in a defined legal relationship, whether contractual or not. The agreement can be an arbitration clause within a contract or a separate agreement. Must be in writing. It can be signed by the parties or in an exchange of letters, telex, telegrams, or other means of telecommunication which provide a record of the agreement. 92nd question is: under what circumstances the arbitral proceedings can be terminated? 1. Final arbitral award. 2. Interim award. 3. Where the arbitral tribunal issues an order for the termination. The correct option is A, 1 and 3. According to Section 32 of the Arbitration and Conciliation Act, 1996, the arbitral proceedings can be terminated in the following circumstances. First, when the final arbitral award is made by the arbitral tribunal. Second, when the parties agree to terminate the proceedings by mutual consent. Third, when the arbitral tribunal issues an order for the termination of the proceedings, either because the claimant withdraws the claim, or because the continuation of the proceedings has become unnecessary or impossible. Whereas an interim award is not a ground for termination of the arbitral proceedings, as it does not dispose of the entire dispute between the parties. An interim award is a provisional decision on a specific issue or claim that is subject to the final award. 93rd question is: under Section 29 of the Arbitration and Conciliation Act, 1996, arbitral proceedings with more than one arbitrator, any decision of the arbitral tribunal dash. The correct option is D, shall be made by majority of its members. This is because the Arbitration and Conciliation Act, 1996 states that Section 29, decision making by panel of arbitrators. Majority decision. In arbitral proceedings with more than one arbitrator, any decision of the arbitral tribunal shall be made by a majority of all its members. Exception: if authorized by the parties or all members of the arbitral tribunal, questions of procedure may be decided by a presiding arbitrator. 94th question is: the provision for maintenance pendente light in Hindu Marriage Act, 1955 is given in dash. The correct option is C, Section 24. The term maintenance pendente light means maintenance pending the litigation, and it is a temporary measure to provide financial support to the dependent spouse while the suit is pending. Either the wife or the husband can apply for maintenance and expenses during the pendency of the proceedings. The applicant must lack independent income sufficient for their support and to meet the necessary expenses of the proceeding. The court may order the respondent to pay the applicant such sum as it deems reasonable, having regard to the applicant's own income and the income of the respondent. 95th question deals with Muslim law. A Muslim wife may sue for divorce under the Dissolution of Muslim Marriage Act, 1939 Section 2, if the husband has been insane for a period of. The correct option is B, 2 years. According to the Dissolution of Muslim Marriages Act, 1939 Section 2, one of the grounds for a woman married under Muslim law to obtain a decree for the dissolution of her marriage is that the husband has been insane for a period of 2 years or is suffering from a virulent venereal disease. This means that if the husband has been mentally unstable or afflicted with a serious sexually transmitted infection for 2 years or more, the wife can seek a divorce from him. The other options are incorrect because they do not match the duration specified in the Act. When it comes to Hindu Marriage Act, 1955, the same provision is defined under Section 13, Grounds for Divorce. A Hindu spouse can seek a divorce on various grounds, including insanity. Section 13 of 1 of 3 provides that a spouse can seek a divorce if the other party has been incurably of unsound mind, or has been suffering continuously or intermittently from a mental disorder of such a kind and to such an extent that the petitioner cannot reasonably be expected to live with the respondent. 96th question is: Muslim woman has option to be governed by the provisions of sections 125 to 128 of Criminal Procedure Code 1973. Which section of the Muslim Women, Protection of Rights on Divorce, Act, 1986 deals with it? The correct option is A, Section 5. This section of the Muslim Women, Protection of Rights on Divorce, Act, 1986 deals with the option of a divorced Muslim woman to be governed by the provisions of sections 125 to 128 of the Code of Criminal Procedure, 1973. According to this section, if a divorced Muslim woman and her former husband declare, by affidavit or any other declaration in writing in the prescribed form, that they would prefer to be governed by the provisions of sections 125 to 128 of the Code of Criminal Procedure, 1973, then the magistrate shall dispose of such application accordingly. This option is available to the divorced Muslim woman at the time of filing an application under Section 3 or Section 4 of the Act. 97th question is: which of the following is not a ground of void marriage under Section 11 of the Hindu Marriage Act? The correct answer is D, child marriage. While child marriage is prohibited and punishable under the Hindu Marriage Act, it is not considered a void marriage under Section 11. Instead, it is classified as a voidable marriage under Section 12 of the Act, which means it is valid until it is annulled by a court. The degrees of prohibited relationship. Two persons are within the degrees of prohibited relationship if they are closely related by blood or marriage. Sapinda relationship. Two persons are sapindas if one is a lineal ascendant of the other within the limits defined. The sapinda relationship extends to the third generation through the mother and the fifth generation through the father. Marriage between sapindas is prohibited unless allowed by custom or usage. Bigamy is nothing but the act of marrying while already having a spouse, and is punishable under sections 494 and 495 of the Indian Penal Code, 1860. If you understood the 97th question, you can easily answer the 98th question. For our explanation purpose, I am providing matter here in this question. Sapinda relationship means. The correct option is B, third generation, mother, fifth generation, father. This is the definition of Sapinda relationship given by Section 3(f) of the Hindu Marriage Act, 1955. According to this section, two persons are said to be Sapindas of each other if they have a common lineal ascendant within the limits of Sapinda relationship, which extends as far as the third generation, inclusive, in the line of ascent through the mother, and the fifth, inclusive, in the line of ascent through the father. This means that a person cannot marry anyone who is related to him or her through the same blood up to 3 generations on the mother's side and 5 generations on the father's side. However, it allows for exceptions based on custom or usage, if such custom or usage permits a marriage between two sapindas of each other. 99th question is: a leading question may be asked in. The correct option is C, cross-examination. Leading questions are specifically utilized during cross-examination to shape the testimony in a way that supports the questioning party's case. This contrasts with examination in chief and re-examination, where leading questions are typically disallowed to maintain the integrity of the witness's testimony. For example, lawyer, isn't it true that you were standing at the corner of Main Street when you saw the accident? This is a leading question. It suggests the answer, the witness was at the corner of Main Street, and is designed to confirm specific details while challenging the witness's testimony. Here is the last question of this series. Extrajudicial confession means. The correct option is A, confessions made either to police or person other than judges and magistrates. An extrajudicial confession is a confession made out of court, and not as a part of a judicial examination or investigation. It can be made to any person. However, such a confession must be corroborated by some other proof of the crime, or else it is insufficient to warrant a conviction. An extrajudicial confession is different from a judicial confession, which is made before a judge or a magistrate in the course of a legal proceeding. A judicial confession has more evidentiary value than an extrajudicial confession, as it is presumed to be free and voluntary. Thanks for tuning into this part of our AIBE 17 analysis series. We hope you found the insights helpful for your exam preparation. If enjoyed the video, please give it a thumbs up, subscribe and hit that notification bell so you don't miss the next part in the series. Share your thoughts or questions in the comments below. We love hearing from you. Until next time, keep studying, stay focused and good luck on your journey. See you in the next series.